Mastering data processing agreements. Data controllers and processors must sign away their freedom to comply. How does a data processing agreement, DPA, serve its purpose in ensuring their compliance with data protection regulations, and what are the key obligations that its signatories must undertake to fulfill their respective roles as data controllers and data processors? A data processing agreement, DPA, is a vital component in ensuring compliance with data protection regulations, particularly the General Data Protection Regulation, GDPR, in the European Union. A DPA is a legally binding contract between a data controller and a data processor that outlines the terms and conditions of processing personal data. The agreement serves its purpose by providing a framework for the processor to follow when handling the controller's personal data, ensuring that the processing is done in accordance with the applicable data protection laws and regulations. The key obligations that the signatories must undertake to fulfill their respective roles as data controllers and data processors are as follows. Data controller obligations. 1. Specify the purpose and scope of data processing. The data controller must clearly define the purpose and scope of the data processing, ensuring that the data processor is aware of the specific tasks and activities that need to be performed. 2. Ensure lawful processing. The data controller must ensure that the processing of personal data is lawful, fair, and transparent, and that it has obtained the necessary consent from the data subjects or relied on another legitimate basis for processing. 3. Select a reliable data processor. The data controller must choose a data processor that provides sufficient guarantees to implement appropriate technical and organizational measures to ensure the security of the personal data. 4. Provide instructions to the data processor. The data controller must provide the data processor with clear instructions on how to process the personal data, including the security measures to be implemented, data retention periods, and data subject rights. 5. Monitor the data processor's activities. The data controller must regularly monitor the data processor's activities to ensure compliance with the DPA and applicable data protection laws and regulations. Data processor obligations. 1. Process personal data only as instructed. The data processor must only process personal data in accordance with the instructions received from the data controller, unless required to do so by applicable law. 2. Implement appropriate technical and organizational measures. The data processor must implement appropriate technical and organizational measures to ensure the security of the personal data, including encryption, access controls, and incident response plans. 3. Ensure confidentiality. The data processor must ensure that its employees and subcontractors are bound by confidentiality obligations, and that they only process personal data as necessary to perform their duties. 4. Assist the data controller in complying with its obligations. The data processor must assist the data controller in complying with its obligations under the applicable data protection laws and regulations, including responding to data subject requests and notifying data breaches. 5. Notify the data controller of data breaches. The data processor must notify the data controller without undue delay in the event of a data breach, providing the controller with sufficient information to enable it to comply with its breach notification obligations. Other key provisions. 1. Audit and inspection rights. The data controller may have the right to audit and inspect the data processor's facilities, procedures, and systems to ensure compliance with the DPA and applicable data protection laws and regulations. 2. Sub-processing. The data processor must obtain the data controller's prior written consent before engaging a sub-processor, and ensure that the sub-processor is bound by the same obligations as the data processor. 3. Liability and indemnification. The DPA must specify the liability and indemnification provisions in the event of a data breach or non-compliance with the agreement, ensuring that the data controller is protected in case of a failure by the data processor. 4. Term and termination. The DPA must specify the term and termination provisions, including the procedures for returning or deleting personal data at the end of the agreement. 5. Governing law and jurisdiction. The DPA must specify the governing law and jurisdiction that will apply to the agreement, ensuring that the parties are clear on the applicable laws and regulations. In conclusion, a DPA is a critical component in ensuring compliance with data protection regulations, and its signatories must undertake specific obligations to fulfill their respective roles as data controllers and data processors. By following these guidelines, organizations can ensure that their processing of personal data is lawful, fair, and transparent, and that they are protected from potential risks and liabilities.